Hi, welcome back to another episode of Ex Ante. Today we're going to discuss the case of Fiest Publications Incorporated versus Rural Telephone Services Company. This case was heard in the Supreme Court of the United States in the year 1991. Justice Sandra O'Connor delivered the opinion. Let's go ahead and jump into it. The facts of the case. Fiest Publications was a telephone book publisher. So they would send telephone books to people and they didn't get paid because people were buying the telephone books. They got paid by the advertisements that they inserted into the telephone books. Rural Telephone Services Company, they provided their customers with telephone services. So they were a telephone service supply company. In addition, they published a telephone book of their own, but they just published that to the people with that had accounts with them, right? So like in the boundary, because they had a monopoly over a boundary. So you have a telephone servicing company, Rural, that also publishes telephone books, and then you have just a telephone book publishing company, Fiest Publications. Fiest Publications is much more broad in scope than Rural. Rural was just providing a telephone book for a small area, whereas Fiest wanted to provide a feast of telephone book information, so a much larger area. I think it's like 7 or 8 times larger as far as the numbers go. In Fiest's pursuit to publish a telephone book, they came into some trouble because they needed to get the information of the individuals that were within Rural Telephone Services Company. So if you envision Fiest servicing an area this big, Rural serviced an area much smaller inside of that, and they needed the information there. They offered to pay the Rural Telephone Services Company for this information. Rural said, "We're not paying you, we're not going to give it to you. We want to have the monopoly on the telephone book in our area." So Fiest decided that if they wouldn't give them the information of the telephone company in that area, then they would just copy the information out of their book, put it into their own book, and just see what happens. So that's exactly what Fiest did. They just copied the information out of Rural's telephone book without paying for it and published it in their book. It was much more vast. Rural Telephone Services obviously felt that this was a problem, so they sued Fiest for copyright infringement, and that's the ultimate action of the case. Is it's a suit for copyright infringement by Rural Telephone Services Company against Fiest. So the reason we have Fiest listed first here in the case is because they appealed the case up to the Supreme Court. So the ruling is interesting because it runs through a lot of aspects of copyright law, and it also delineates a difference in what the court might consider original creations of work. So they say that facts themselves are not original creations, but compilations of facts are original. So the Rural Telephone Services Company wanted to argue that the compilation of facts, namely the addresses, phone numbers, names of individuals, was protected by copyright law, whereas Fiest was arguing that it was just a fact, just a facet. So it was just a fact of the piece of that larger creation. The court ultimately did rule in favor of Fiest, and they held that although the compilation of the facts might be copyrightable, the individual facts themselves are not copyrightable. So Fiest was able to go ahead and publish their book and continue working happily, and Rural was obviously very mad. I think it's worth reading a quote out of the case. "The question that remains is whether Rural selected, coordinated, or arranged these uncopyrightable facts in an original way. As mentioned, it is not a stringent standard for originality. It does not require that the fact be presented in an innovative or surprising way. However, the selection and arrangement of the facts cannot be so mechanical or routine as to require no creativity whatsoever. The standard of originality is low, but it does exist." So Justice O'Connor is saying that although the standard for originality as a facet of having a copyrightable work is low, there has to be some type of creation, and just listing facts in an alphabetical order in a book isn't truly creative. So that's the ruling. The precedent would be that the facts themselves in a factual compilation aren't copyrightable, but the compilation itself, if it's original, is copyrightable. All right, so let's go ahead and jump into the ex ante implications. The first I want to do is, what if Rural just would have been a little bit more unique in the way that it would have published the facts? So like these addresses, numbers, and names. What if they would have said if they would have like a yearbook, inserted a quote from each one of the individuals into the telephone book, then would it have been original enough to say that, hey, this actually is a work of art? I think that's likely. Whether the facts themselves would be protected because of that still would be up to the court to see. But there could be some ways around this just by enhancing the originality of your facts a little bit. And that was done in another case with a telephone book that said that they were just holding all the information of businesses that Chinese Americans might be interested in shopping at. The court held that that was original enough to constitute a copyrightable work because it was just narrowly tailored in its audience. So something to think about a little bit more there. Finally, one more scenario that I want to jump into that I think might display some unintuitive results of this precedent would be if we had a chemist who, published a catalog maybe once a year of chemical equations, and he just published those and he sought copyright for it. Maybe he got copyright. And someone looked at his book, just found those chemical equations and published them in a book of their own. Well, if chemical equations truly are just an instance of fact, which I think most of us would agree they are, chemical equations are absolute, they're independent of the chemist. The chemist is just identifying the facts there. Can the chemist actually have any type of copyright claim on someone who just takes those chemical equations that he's published and puts them into a new book of their own? I think underneath Fiest, he likely wouldn't have any claim against the author who just took those equations and published them in a book of their own, because they are just facts ultimately. So thanks so much for watching. If you enjoyed this video and you'd like to see more, go ahead and hit the subscribe button, and I hope you have a nice rest of your day. Bye.